Does seizing frozen Russian assets break international law? European leaders and MEPs have been ramping up calls to seize €274 billion in frozen Russian assets to support Ukraine's military and help rebuild the country. They were frozen by the EU, US and allies after Russia launched its full-scale invasion of Ukraine. Meanwhile, other politicians have been wary of such a move due to the potential legal repercussions. The majority of these assets are held in the securities depository Euroclear, which is based in Belgium. The money was originally in short-term government bonds held as reserves for the Russian central bank, but those bonds have now matured and are piling up. Russia has called the plans illegal. So, what does international law say about this?
If there is a court order that orders governments to seize the assets of Russia, that court order would be illegal under international law and under domestic law, which imports international law. However, if there is an executive decision, by the government to seize the asset, that could bypass potentially this.
Seizing Russian assets would only be legal if the decision was enacted as a countermeasure.
It's not a retribution, it's to induce compliance. So Russia should have the opportunity to say, I'm sorry, I'm going to rectify whatever, I'm going to pay damages, and then you leave my assets, you don't touch them. Second, countermeasure must be temporary. They cannot be indefinite.
In May 2024, EU member states did, however, begin using interest from frozen assets to finance Ukraine's military effort. While Russia labelled this theft, it was permitted under international law as it is considered a temporary measure.